Griffith-Jones. Yes.
May it please the tribunal. Lord, count 2 of the indictment charges these defendants with participating in the planning, the preparation, the initiation, and waging of various wars of aggression. And it charges that those wars are also in breach of international treaties. Lord, it is my purpose now to present to the tribunal the evidence in respect of those aggressive wars against Poland and against the United Kingdom and France. Under paragraph B of the particulars to count 2, reference is made to count 1 in the indictment for the allegations charging that those wars were wars of aggression. And count 1 also sets out the particulars of the preparations and planning for those wars, and in particular, those allegations will be found in paragraph F4. But, my Lord, with the tribunal's approval, I would propose first to deal with the allegations of breach of treaties which are mentioned in paragraph C of the particulars, and of which the details are set out in Appendix C. Lord, those sections of Appendix C which relate to the war against Poland are Section 2, which charges a violation of the Hague Convention in respect of the Pacific settlement of international disputes, of which Sir David has already addressed the court, and I don't propose, with the court's approval, to say more than that. Section 3 of Appendix C and Section 4 charge breaches of the other Hague Conventions of 1907. Section 5.4, 5 subsection 4, charges a breach of the Versailles Treaty in respect of the free city of Danzig, and Section 13, a breach of the Kellogg-Briand Pact. All those have already been dealt with by Sir David Maxwell Fyfe, and it remains therefore only for me to deal with 2 other sections of Appendix C. Section 10, which charges a breach of the arbitration treaty between Germany and Poland, signed at Locarno on the 16th of October 1925, and Section 15 of Appendix C, which charges a violation of the Declaration of Non-Aggression, which was entered into between Germany and Poland on the 26th of January 1934. If the tribunal would take Part 1 of their British document book number 2, but I will describe in a moment how the remaining parts are divided. The document book is divided into 6 parts. The tribunal would look at part 1 for the moment. The document books which have been handed to the defense counsel are in exactly the same order, except that they are bound in 1 and not in 6 separate covers in which the tribunal's documents are bound for convenience. The German-Polish arbitration treaty, the subject matter of section 10 of Appendix C, is document TC 15 and appears, it's the one but end document in the book. What is that number? That's been put in. It has already been put in under the number GB 16. Lord, I would quote the preamble and Articles 1 and 2 from that treaty. The President of the German Empire and the President of the Polish Republic equally resolved to maintain peace between Germany and Poland by assuring the peaceful settlement of differences which might arise between the two countries, declaring that respect for the rights established by treaty or resulting from the law of nations is obligatory for international tribunals, agreeing to recognize that the rights of a state cannot be modified save with its consent, and considering that sincere observance of the methods of peaceful settlement of international disputes permits of resolving, without recourse to force, questions which may become the cause of divisions between states, have decided. And they then go on in Article 1. All disputes of every kind between Germany and Poland, with regard to which the parties are in conflict as to their respective rights, and which it may not be possible to settle amicably by the normal methods of diplomacy, shall be submitted for decision either to an arbitral tribunal or to the Permanent Court of International Justice as laid down hereafter. I go straight to Article 2. Before any resort is made to arbitral procedure before the Permanent Court of International Justice, the dispute may, by agreement between the parties, be submitted with a view to amicable settlement to a permanent international commission styled the Permanent Conciliation Commission, constituted in accordance with the present treaty. Lord, thereafter, the treaty goes on to lay down the procedure for arbitration and for conciliation.
It's in the same terms, is it not, as the arbitration treaty between Germany and Czechoslovakia and Germany and Belgium?
Lord, yes, it is, Lord. They're both signed at Locarno in 1925. Lord, the words of the charge in section 10 will be noted, particulars in that Germany did, on or about 1st of September 1939, unlawfully attack and invade Poland, without first having attempted to settle its dispute with Poland by peaceful means. And the only other treaty to which I refer, the German-Polish Declaration of the 26th of January 1934, will be found as the last document in part 1 of the Tribunal's document book, which is the subject of section 10 of Appendix C. The German government and the Polish government, this of course was signed on the 26th of January 1934, the German government and the Polish government consider that the time has come to introduce a new era in the political relations between Germany and Poland by a direct understanding between the states. They have therefore decided to establish, by the present declaration, a basis for the future shaping of those relations. The two governments assume that the maintenance and assurance of a permanent peace between their countries is an essential condition for general peace in Europe.
Do you think it's necessary to read all this? We're taking judicial notice of it.
I'm very much obliged, and I'm only too anxious to shorten this if I can. I would, in view of what is later alleged by the Nazi government, I would particularly draw attention to the last paragraph in that declaration. The declaration shall remain in effect for a period of 10 years, counting from the day of exchange of instruments of ratification. In case it is not denounced by one of the two governments 6 months before the expiration of that period of time, it shall continue in effect, but can then be denounced by either government at a time 6 months at any time 6 months in advance. Lord, I pass then from the breach of treaties to present to the court the evidence upon the planning and preparation of these wars, and in support of the allegation that they were wars of aggression. For convenience, as I say, the documents have been divided into separate parts. And if the tribunal would look at the index, the total index to their document, which is a separate book, on the front page it will be seen how these documents have been divided. Part 1 is the treaties. Part 2 is entitled Evidence of German Intentions prior to March 1939. Might perhaps be more accurately described as pre-March 1939 evidence. And it will be with that part that I would now deal. Lord, it has been put to the tribunal that the actions against Austria and Czechoslovakia were in themselves part of the preparation for further aggression, and I only now, dealing with the early history of this matter, wish to draw the court's particular attention to those parts of the evidence which show that even at that time before the Germans had seized the whole of Czechoslovakia, they were perfectly prepared to fight England, Poland, and France, if necessary, to achieve those preliminary aims, that they appreciated the whole time that they might well have to do so. And what is more, that although not until after March 1939 did they commence upon their immediate and specific preparations for a specific war against Poland, nevertheless they had for a considerable time before had it in mind specifically to attack Poland once Czechoslovakia was completely theirs. During this period also, and this happens throughout the whole story of the Nazi regime in Germany, during this period as afterwards, while they are making their preparations and carrying out their plans, they are giving to the outside world assurance after assurance so as to lull them out of any suspicion of their real objects. The dates, I think, as the learned Attorney General said in addressing you yesterday, the dates in this case, almost more than the documents, speak for themselves. The documents in this book are arranged in the order in which I will refer to them, and the first that I would refer to is document TC 70, which is already before. It's in already. It's not in. It will go in as GB 25. It's only interesting to see what Hitler said of the agreement with Poland when it was signed in January 1934. When I took over the government on the 30th of January, the relations between the two countries seemed to me more than unsatisfactory. There was a danger that the existing differences, which were due to the territorial clauses of the Treaty of Versailles and the mutual tension resulting therefrom, would gradually crystallize into a state of hostility which, if persisted in, might only too easily acquire the character of a dangerous traditional enmity. I'd go down to the one but last paragraph. In the spirit of this treaty, the German government is willing and prepared to cultivate economic relations with Poland in such a way that here too the state of unprofitable suspicion can be succeeded by a period of useful cooperation. It is a matter of particular satisfaction to us that in this same year the National Socialist government of Danzig has been enabled to effect a similar clarification of its relations with its Polish neighbor. That was in 1934. 3 years later, again on the 30th of January, speaking in the Reichstag, Hitler said, now this is document PS 2368, which will be GB 26. I will, if I may, avoid so far as possible repeating passages which the Attorney General quoted in his speech the other day. The first paragraph, in fact, he quoted to the tribunal. It's a short paragraph, and perhaps I might read it now, but I will, in dealing with this evidence so far as possible, avoid repetition. By a series of agreements, we have eliminated existing tensions and thereby contributed considerably to an improvement in the European atmosphere. I merely recall an agreement with Poland which has worked out to the advantage of both sides. True statesmanship will not overlook realities, but consider them. The Italian nation and the new Italian state are realities. The German nation and the German Reich are equally realities. And to my own fellow citizens, I would say that the Polish nation and the Polish state have also become a reality. That was on the 30th of January 1937. On the 24th of June 1937, we have a top-secret order, C-175, which has already been put in as US 69. It is a top-secret order issued by the Reich Minister for War and Commander-in-Chief of the Armed Forces, signed von Blomberg, it has at the top, written by an officer, outgoing documents in connection with this matter and dealing with it are to be written by an officer, so it's obviously highly secret. And with it are enclosed a directive for the unified preparation for war of the armed forces to come into force on the 1st of August 1937. The directive enclosed with it is divided into part one, the general guiding principles, part two, likely warlike eventualities, part three, special preparations. Tribunal will remember that the attorney quoted the opening passages. The general position justifies the supposition that Germany need not consider an attack from any side. Goes on, the second paragraph, the intention to unleash a war is held just as little by Germany. Nevertheless, the politically fluid world situation, which does not preclude surprising incidents, demands a continuous preparedness for war of the German armed forces to counter attacks at any time and to enable the military exploitation of politically favorable opportunities should they occur. It then goes on to set out the preparations which are to be made, and I would particularly draw the Tribunal's attention to paragraph 2b, the further working on mobilization without public announcement in order to put the armed forces in a position to begin a war suddenly and by surprise, both as regards strength and time. On the next page, under paragraph 4, special preparations are to be made for the following eventualities: armed intervention against Austria, warlike entanglements with Red Spain, and thirdly, and this shows so clearly how they appreciated at that time that their actions against Austria and Czechoslovakia might well involve them in war, England, Poland, and Lithuania take part in a war against us. If the Tribunal would turn over to part 2 of that directive, it's page 5 of that document. Probable warlike eventualities. The following suppositions, aims, and tasks will be made the basis for the treatment of probable warlike eventualities, concentrations. 1. War on two fronts with focal point in the West. The suppositions. In the West, France is the opponent. Belgium may side with France either at once or later or not at all. It is also possible that France may violate Belgium's neutrality if the latter is neutral. She will certainly violate that of Luxembourg. I pass to part 3, which will be found on page 9 of that exhibit. And I particularly refer to the last paragraph on that page. Under the heading Special Case, Extension Red-Green, it will be remembered that red was Spain and green was Czechoslovakia. The military political starting point used as a basis for concentration plans red and green can be aggravated if either England, Poland, or Lithuania join the side of our opponents. Thereupon, our military position would be worsened to an unbearable, even hopeless extent. The political leaders will therefore do everything to keep these countries neutral. Above all, England and Poland. thereafter, it sets out the conditions which are to be the basis for the discussion. But I leave that document. The date will be noted, June 1937, and it shows clearly that at that date, anyway, the Nazi government appreciated the likelihood, if not the probability, of fighting England and Poland and France, and were perfectly prepared to do so if they had to. On the 5th of November, 1937, the tribunal will remember that Hitler held his conference in the Reichschancellery, the minutes of which have been referred to as the Hossbach note. I only refer to one or two lines of that document to draw the attention of the tribunal to what Hitler said in respect of England, Poland, and France. On page 1 of that exhibit, in the middle of the page, the Führer then stated, "The aim of German policy is the security and preservation of the nation and its propagation. This is consequently a problem of space." He then went on, it will be remembered, to discuss what he described as autarky, participation in world economy, and at the bottom of page 2, he said, "The only way out, and one which may appear imaginary, is the securing of greater living space, an endeavor which at all times has been the cause of the formation of states and movements of nations." And at the end of that first paragraph on page 3, "The history of all times, Roman Empire, British Empire, has proved that every space expansion can only be effected by breaking resistance and taking risks. Even setbacks are unavoidable. Neither formerly nor today has space been found without an owner. The attacker always comes up against the proprietor." My Lord, so that it is clear that that reference was not only
been read already.
Not, if my object was only to try to collect, so far as England and Poland were concerned, the evidence that had been given, I would welcome, in actual fact, if the tribunal thought that it was unnecessary, I would welcome the opportunity to...
I think the tribunal would wish you not to read anything that has been read already.
Lord, I would pass then to the next document in that part of your document book. I put that document in. It was referred to by the Attorney General in his address yesterday, and it shows that on the same date as the Hossbach meeting was taking place, a communique was being issued as a result of the Polish ambassador's audience with Hitler, which it was said in the course of the conversation, it was confirmed that Polish-German relations should not meet with difficulties because of the Danzig question. That document is TC 73. I put it in as GB 27. On the 2nd of January...
Well, that hasn't been read before, has it? Or has it? Has that been read before?
It was read. It was read by the Attorney General in his opening.
Oh, in his opening. Well, very well.
On the 2nd of January, 1938, some unknown person wrote a memorandum for the Führer. This document was one of the German Foreign Office documents of which a microfilm was captured by Allied troops when they came into Germany. It is headed very confidential, personal only. And is called Deductions on the Report, German Embassy, London, regarding the future form of Anglo-German relations. With the realization that Germany will not tie herself to a status quo in Central Europe, and that sooner or later a military conflict in Europe is possible, the hope of an agreement will slowly disappear among Germophile British politicians, insofar as they are not merely playing a part that has been given to them. Thus, the fateful question arises, will Germany and England eventually be forced to drift into separate camps, and will they march against each other one day? To this question, to answer this question, one must realize the following. A change of the status quo in the East, in the German sense, can only be carried out by force. As long as France knows that England, which, so to speak, has taken on a guarantee to aid France against Germany, is on her side, France's fighting for her Eastern allies is probable. In any case, always possible, and thus with it, a war between Germany and England. This applies then, even if England does not want war. England, believing she must defend her borders on the Rhine, would be dragged in automatically by France. In other words, peace or war between England and Germany rests solely in the hands of France, who could bring about such a war between Germany and England by way of a conflict between Germany and France. It follows, therefore, that war between Germany and England on account of France can be prevented only if France knows from the start that England's forces would not be sufficient to guarantee their common victory. Such a situation might force England, and thereby France, to accept a lot of things that a strong Anglo-French coalition would never tolerate. This position would arise, for instance, if England, through insufficient armament or as a result of threats to her empire, by a superior coalition of powers, e.g. Germany, Italy, Japan, thereby tying down her military forces in other places, would not be able to assure France of sufficient support in Europe. The next page goes on to discuss the possibilities of a strong partnership between Italy and Japan. And I would pass for my quotation to the next page, where the writer is summarizing his ideas. Paragraph 5. Therefore, conclusions to be drawn by us. 1. Outwardly further understanding with England in regard to the protection of the interests of our friend. 2. Formation, under great secrecy, but with wholehearted tenacity, of a coalition against England. That is to say, a tightening of our friendship with Italy and Japan, also the winning over of all nations whose interests conform with ours, directly or indirectly, close and confidential cooperation of the diplomats of the three great powers towards this purpose. Only in this way can we confront England, be it in a settlement or in war. England is going to be a hard and astute opponent in this game of diplomacy. The particular question whether in the event of a war by Germany in Central Europe, I'm afraid the translation of this is not very good. The particular question whether in the event of a war by Germany in Central Europe, France and thereby England would interfere, depends on the circumstances and the time at which such a war commences and ceases, and on military considerations which cannot be gone into here. And whoever it was that wrote that document, he appears to be on a fairly high level, because he concludes by saying, I should like to give the Führer some of these points of view verbally. That document is GB 28. Well, I'm afraid the next two documents have got into your books in the wrong order. If you would refer to PS 2357, which is the one following on L43. It will be remembered that that document to the Führer, which I've just read, was dated the 2nd of January, 1938. On the 20th of January, 1938, Hitler spoke in the Reichstag.
February, the document says.
I beg your pardon, February 1938. That is PS 2357 and will be GB 30. In that speech he said, in the 5th year following the first great foreign political agreement with the Reich, it fills us with sincere gratification to be able to state that in our relations with the state with which we had perhaps the greatest differences, not only has there been a détente, but in the course of these years there has been a constant improvement in relations. This good work, which was regarded with suspicion by so many at the time, has stood the test. And I may say that since the League of Nations finally gave up its continual attempts to unsettle Danzig and appointed a man of great personal attainments as the new commissioner, the most dangerous spot from this point of view of European peace has entirely lost its menacing character. The Polish state respects the national conditions of this state, and both the city of Danzig and Germany respect Polish rights. And so the way to a friendly understanding has been successfully paved, an understanding which, beginning with Danzig, has today, in spite of the attempts of certain mischief makers, succeeded in finally taking the poison out of the relations between Germany and Poland and transforming them into a sincere, friendly cooperation. Relying on her friendships, Germany will not leave a stone unturned to save that ideal which provides the foundation for the task which is ahead of us, peace. I turn back to the to the document which was in your document books, the one before that, L43, which will be GB 29. So this is you got the original. This is a document to which the Attorney General referred yesterday. It is dated the 2nd of May 1938 and is entitled Organizational Study of 1950. It comes from the office of the Chief of the Organizational Staff of the General Staff of the Air Force. And its purpose is said to be, the task is to search within a framework of very broadly conceived conditions for the most suitable type of organization of the Air Force. The result gained is termed distant objective. From this shall be deduced the goal to be reached in the second phase of the setting up process in 1942. This will be called Final Objective 1942. This in turn yields what is considered the most suitable proposal for the reorganization of the staffs of the Air Force group commands, etc. The table of contents, the tribunal will see, is divided into various sections, and section 1 is entitled Assumptions. With that, the tribunal will turn over one finds that section on the next page, and the assumptions, under the heading Assumptions, 1, Frontiers of Germany, see map, enclosure 1. The tribunal sees a reproduction of that map on the wall. And it will be seen that on the 2nd of May, 1938, the Air Force were envisaging Estonia, Latvia, Lithuania, Poland, Czechoslovakia, and Austria and Hungary, all coming within the bounds of the Reich. The original map is here attached to this file. And if the tribunal look at the original exhibit, it will be seen that this organizational study has been prepared with the greatest care and thoroughness, with a mass of charts attached as appendices. I would refer also to the bottom of the second page of the tribunal's copy of the translation, consideration of the principles of organization on the basis of the assumptions for war and peace made in section 1. 1. Attack forces. Principal adversaries: England, France, Russia. And it then goes on to say, if all the 144 Geschwader are employed against England, they must be concentrated in the western half of the Reich, that is to say, they must be deployed in such a way that by making full use of their range, they can reach all English territory down to the last corner.
It's perhaps involved in the map, but I think perhaps you should refer to the organization of the Air Forces, or the Air Force, with group commands at Warsaw and Königsberg.
I'm much obliged. Under the paragraph Assumptions, subheading 2, Organization of the Air Force in Peacetime, 7 group commands, 1 Berlin, 2 Brunswick, 3 Munich, 4 Vienna, 5 Budapest, 6 Warsaw, 7 Königsberg.
Yes.
I'm very much obliged. And lastly, in connection with that document, on page 4 of the tribunal's translation, the last paragraph, the more the Reich grows in area, and the more the Air Force grows in strength, the more imperative it becomes to have locally bound command. I only emphasize the opening. The more the Reich grows in area, the more the Air Force grows in strength. Lord, I would say one word on that document. The original, I understand, is signed by an officer who is not at the top rank in the Air Force. And I therefore don't want to overemphasize the inferences that can be drawn from it. But it is submitted that it at least shows the lines upon which the General Staff of the Air Force were thinking at that day.
Let me just give a number to that.
The tribunal will remember that in February 1938, the defendant Ribbentrop succeeded von Neurath as foreign minister. We have another document from that captured microfilm, which is dated the 26th of August 1938, when Ribbentrop had become foreign minister, and it is addressed to him as the Reich minister via the state secretary. Lord, it is a comparatively short document, and one that I will read the whole of. The most pressing problem of German policy, the Czech problem, might easily, but must not, lead to a conflict with the Entente. Well, this is TC 76, I'm afraid I didn't give you the number. TC 676 becomes GB 31.
GB what?
31.
Yes.
Neither France nor England are looking for trouble regarding Czechoslovakia. Both would, perhaps, leave Czechoslovakia to herself if she should, without direct foreign interference and through internal signs of disintegration due to her own fault, suffer the fate she deserves. This process, however, would have to take place step by step and would have to lead to a loss of power in the remaining territory by means of a plebiscite and an annexation of territory. The Czech problem is not yet politically acute enough for any immediate action, which the Entente would watch inactively, and not even if this action should come quickly and surprisingly. Germany cannot fix any definite time, and this fruit could be plucked without too great a risk. She can only prepare the desired developments. I pass to the last paragraph on that page. I think I can leave out the intervening lines. Paragraph 5. This method of approach...
Colonel Griffith-Jones, should you not read the next paragraph?
If you're not
For this purpose.
For this purpose, the slogan emanating from England at present of the right for autonomy of the Sudeten Germans, which we have intentionally not used up to now, is to be taken up gradually. The international conviction that the choice of nationality is being withheld from these Germans will do useful spade work. And notwithstanding the fact that the chemical process of dissolution of the Czech form of states may or may not be finally speeded up by mechanical means as well. The fate of the actual body of Czechoslovakia, however, would not as yet be clearly decided by this, but would nevertheless be definitely sealed. This method of approach towards Czechoslovakia is to be recommended because of our relationship with Poland. It is unavoidable that the German departure from the problems of boundaries in the southeast and their transfer to the east and northeast must make the Poles sit up. The fact is, I put in an is because I think it's obviously left out of the copy that I have in front of me. The fact is that after the liquidation of the Czech question, it will be generally assumed that Poland will be the next in turn. But the later this assumption sinks in international politics as a firm factor, the better. In this sense, however, it is important for the time being to carry on the German policy under the well-known and proved slogans of the right to autonomy and racial unity. Anything else might be interpreted as pure imperialism on our part and create the resistance to our plan by the Entente at an earlier date and more energetically than our forces could stand up to. That was on the 26th of August, 1938, just as the crisis, the Czech crisis, was leading up to the Munich settlement. While at Munich, or rather while a day or two before the Munich agreement was signed, Hitler made a speech. On the 26th of September, he said, I think this is, Sir David Maxwell Fact has only just read this document to the tribunal, so I'll only refer to 2 lines of it. I assured him, moreover, and I repeat it here, that when this problem is solved, there will be no more territorial problems for Germany in Europe. And again, the last document in your book, which is another extract from that same speech. I will not read to the tribunal unless the tribunal desire, because the Attorney General did quote it in full in his address yesterday. Those 2 documents TC 28 is already in as GB 22 and TC 29, which is the second extract from that same speech, GB 32.
TC 29. TC 28.
Lord, I would refer the tribunal to one more document under this part, which has already been put in by my American colleagues. It is C-23, now US 49, and which appears before TC-28 in your document book. The particular passage of that exhibit to which I would refer is a letter from Admiral Carles, which appears at the bottom of the second page. It is dated sometime in September, no precise date, and is entitled Opinion on the Draft Study of Naval Warfare Against England. There is full agreement with the main theme of the study. And again, the Attorney General quoted the remainder of that letter yesterday, which the tribunal will remember. If, according to the Führer's decision, Germany is to acquire a position as a world power, she needs not only sufficient colonial possessions, but also secure naval communications and secure access to the ocean. That then was the position at the time of the Munich Agreement in September 1938. The gains of Munich were not, of course, so great as the Nazi government had hoped and had intended. And as a result, they were not prepared straight away to start any further aggressive action against Poland or elsewhere. But your lordships heard this morning when Mr. Alderman dealt in his closing remarks with the advantages that were gained by the Caesar of Czechoslovakia, what Jodl and Hitler said on subsequent occasions, that Czechoslovakia was only setting the stage for the attack on Poland, it is, of course, obvious now that they intended and indeed had taken the decision to proceed against Poland so soon as Czechoslovakia had been entirely occupied. We know now from what Hitler said in talking to his military commanders at a later date. Tribunal will remember the speech where he said that from the first he never intended to abide by the Munich Agreement, but that he had to have the whole of Czechoslovakia. As a result, although not ready to proceed in full force against Poland after September 1938, they did at once begin to approach the Poles on the question of Danzig, until, as the tribunal will see, until the whole of Czechoslovakia had been taken in March, no pressure was put on. But immediately that the Sudeten land had been occupied, preliminary steps were taken to stir up trouble with Poland, which would and was to eventually lead to their excuse or so-called justification for their attack on their country. If the tribunal would turn to part 3 of their document.
It's time to adjourn now. 10 o'clock tomorrow morning.